Hello, I've returned with another ADH Wealth solution. Today, we will begin to discuss fulfilling all of your financial needs. As always, this is a basic description. For an evaluation of your own, please schedule an appointment. My information is in the description. Lastly, make sure you hit the like, drop a comment, and if you're new, subscribe and hit the notification bell so you're made aware every time I release new content. Today, we'll read an article by Think Advisor regarding a Georgia federal judge and an insurance company sued for life race bias claims. Georgia federal judge tosses industrial life race bias claims by Greg Land, June 7th, 2021. A federal judge in Savannah, Georgia, has dismissed a punitive class action leveling claims of racial discrimination against an insurance company over its marketing of industrial life policies, relatively low-value policies that can end up paying less than the accrued premiums. The complaint accused United Insurance Company of America of targeting black households for sales of its industrial life policies, described as those that usually have a face value between $1,000 and $5,000, generally intended to cover funeral and other end-life expenses. The complaint, filed in Georgia's Southern U.S. District Court, accused United of unlawful, unconscionable, and racially discriminatory conduct in relation to the policies, asserting that the named plaintiff's husband, Chester Barrett, paying monthly premiums of $36 for a policy he bought in 1984 that paid $5,000 upon his death. By then, he'd paid more than $14,600 for the coverage. What that means is likely he endowed the policy or outlived the policy, and the company should have paid him back his accrued cash value. But Judge R. Stan Baker said there was no indication that United currently charged black policyholders any more than it does white ones, nor that it misled the insurance purchasers about the cost or face value of the coverage. In 2002, he noted, United had settled a discrimination class action over claims it charged black customers higher rates than whites. But, he said, according to United's in-house counsel who investigated allegations in the 2002 class action, United stopped selling policies with race-based rate scales and using race-based underwriting practices by the 1970s. Additionally, he said, neither party disputes that United stopped selling life insurance policies and that used a different rate scale for African American customers and Caucasian customers. Well, before Mr. Barrett purchased his policy, and they also agree that United did not have a policy or practice of marketing or underwriting life insurance policies based on the race of its customers at the time that Mr. Barrett purchased his policy. In any case, Baker said, the claims were also barred by the statute of limitations. While the lawyers for Barrett's widow, Minerva Barrett, had argued that the statute was told by United's fraudulent actions in marketing the policies, she said has failed to provide any evidence that United committed fraud when it sold Barrett his policy, the judge said. He also discounted the testimony of an expert, Emetrius, Professor Robert Klein of Georgia State University's Department of Risk Management and Insurance, who states that Mr. Barrett had a type of policy that is heavily marketed to low-income individuals, particularly African Americans, and that generally industrial life policies are directly linked to and reliant upon racial discrimination. Dr. Klein's affidavit makes broad statements about industrial life policies in general, and despite providing no data or analysis concerning United's policies or practices, it leaps to the conclusion that United engaged in unfair practices in its marketing, sales, and administration of Mr. Barrett's policy, the judge said. Notably, however, wrote Baker, the affidavit does not include an opinion regarding whether United exclusively marketed its insurance policies with high premiums towards African Americans, or that African Americans were, by and large, the only group who purchased policies from United. In addition to claims that United's practices violated Section 1981 of the U.S. Civil Rights Act, the suit included state law claims for money had and received, fraudulent inducement, and neglect misrepresentation. The complaint had requested class certification for anyone who has or had an ownership interest in a United industrial policy that was in force on or after January 1, 1970. That charged higher interest rates for black policyholders than whites and or anyone who had one of the non-discriminatory policies issued after January 1, 1988. Because the court finds that plaintiff has put forth insufficient evidence to support any of her substantive claims, no claims remain for the court to consider whether class certification is appropriate, Baker wrote, dismissing the case on summary judgment. Barrett's attorney, R. Bart Turner of Savannah's Savage Turner, Pinky and Savage, said he had not yet discussed the order with his client and was reviewing it for a possible appeal. The lawyers representing United, Locke Lord partners Taylor Brinkman, Elizabeth Campbell, and Roger Cowie, did not respond to a request for comment Monday. The case is in the U.S. District Court for the Southern District of Georgia. Is captioned Barrett v. United Insurance Company of America, number 417 CV 00215 in the Georgia courts system. Interested in having an evaluation? Find my contact info in the description and schedule a consult to explore your options. Have a financial question but don't know who to ask? Email me at a.hall@cgwealth.financial and your question may be answered in my next video. Security products are subject to investment risks, including possible loss of principal. Before investing, carefully consider the investment objectives, risks, limitations, charges, and expenses of the product and any underlying investment options. This information can be found in the product and investment option prospectuses. Copies are available from your registered representative.